in cases involving the OSP and stating the position of the office on the opinion in question as to whether the opinion progresses the fight against corruption or inhibits the fight against corruption. This policy is as novel as the office itself, and much like every aspect and operation of this office, the policy has generated public debate on its propriety or otherwise. Those who applaud this policy of transparency see it for what it is: public information and assurances of the position of the office on the fight against corruption, and nothing more. Those who decry it see it as an attack on the judiciary. Indeed, I have had several calls from well-meaning lawyers admonishing me that they have heard talk that our friends who have been elevated to the bench and presiding over cases in court do not take very kindly to criticism, especially of the public calling out variety as we do. And that if the office persists in the media releases, the judges will gang up against the office and throw out all our cases. Mind you, members of the press, the collective admonition is from very senior and experienced lawyers who are men and women of the world. Members of the press, my learning of the law for the past 25 years in 3 different jurisdictions, my teaching and training of lawyers and law students for the past 17 years, my 20-year record at the bar, all bear testimony that I will be the last person to head and lead an institution to attack the judiciary. It will be absolutely of no good and utility should it be the case that the OSP is set against the judiciary, or that the judiciary is against the OSP. That will surely spell disastrous consequences for this republic, especially in the fight against corruption, to the unending glee of corrupt persons. The OSP will not countenance for a moment such an impression. What we do is a statement of our position on judicial pronouncements in the context of the fight against corruption and whether it benefits the quest against corruption or otherwise. And this is so whether the judicial decision in question is favorable to the OSP or not. And to the well-meaning lawyers who call to admonish me, I always assure them that I do not believe that our judges see themselves as above criticism. Indeed, I vividly recollect when years ago, as a private practitioner, a justice of the Supreme Court softly chastised me in open court that I was not churning out enough published articles in critique of their work, because I was a lecturer at the University of Ghana. The judge added that criticism of judicial pronouncements was essential in guiding judges, and he fondly recollected the regular publications of old in the University of Ghana Law Journal and the Review of Ghana Law. I reckoned the judge's observation with admiration. Collectively with the well-meaning lawyers who admonish me, we philosophize and wonder if our judges would do such a thing as gang up against the flagship public anti-corruption agency to scuttle its work for whatever reason. Our musings ran along the lines of, would that not defeat the fight against corruption? Would that not put our young democracy in danger? Will the judges not stultify themselves in the process? We always end with an open-ended sigh, sometimes a sigh of relief, sometimes a sigh of concern, that may that never be the case. And personally, I do not believe that our judges will ever adopt such a dystopian stance. However, members of the press, there appears to be a developing trend of rather regressive and dismissive judicial decisions in respect of cases involving the OSP, with troubling consequences. And it seems to us that a careful examination of these outcomes portends a disturbing specter that the fight against corruption is being hampered to the disbenefit of us all. And I do not say these things lightly. 4 instances will suffice. In one case, the OSP applied to the High Court for a confirmation of a freezing order in respect of a deceased person's estate. The judge refused to confirm the order by, in effect, holding that the OSP had come too late since the person of interest had died, and that his death had extinguished the inquiry commenced after the occurrence of death. We publicly commented on this outcome, and the danger of this outcome is obvious, members of the press. It is to the effect that a person may, in his lifetime, acquire property through corruption, and then upon his demise, happily pass on the corruptly acquired property to his estate, and by so doing, extinguish all scrutiny as to the propriety or otherwise of the acquisition of the property, because his corrupt activities were not discovered during his lifetime. In the second instance, the OSP had declared as wanted a person it believed to be a fugitive from justice. The person, through his lawyer, proceeded to the Human Rights Court on an ex parte application, and the judge, without even an inquiry as to why the OSP believed him to be a fugitive from justice, issued an injunction that the OSP should not arrest the person for a period of 10 days. Members of the press, this is dangerous. It encourages criminal suspects to go before the courts to seek injunction orders against law enforcement agencies from apprehending them. The judge did not advert his mind to the well-founded proposition that no one has the right not to be arrested, and he accorded the suspect a right not to be arrested. In the third instance, the OSP applied to the High Court for a confirmation of a seizure order and a freezing order in respect of a person who had just resigned from a ministerial position and had reported that large cash sums in foreign denominations had been stolen from her residence. In addition, the OSP subsequently discovered additional large cash sums in foreign denominations and cedis still stashed in her residence. The judge hastily dismissed the OSP's application and ordered a return of the seized amounts and the defreezing of her property, and he proceeded to lash out at the OSP for not doing a thorough investigation, without the slightest consideration that the seizure and freezing orders are designed by law to facilitate investigation into the affairs of suspects, and not the other way around of requiring thorough investigations before the OSP can seize or freeze. The judge also completely ignored the fact that in almost every jurisdiction, including Ghana, it is extremely unusual and highly suspicious for a public officer to have such large cash sums stashed in their homes, and that the circumstances of the case dictated pause and reflection and the granting of the OSP adequate time to carry out its investigation. In our estimation, the judge was only interested in the return of the money to the person of interest and nothing more. Then he proceeded to erect non-existent legal barriers to prevent the OSP from investigating the matter. I'll revisit this case. Members of the press, in the fourth instance, the OSP had issued an investigation report in respect of the grant of a customs advance ruling by the Customs Division of Ghana Revenue Authority. The report opined that there was an institutionalized culture of light-hearted unconcern regarding impropriety of action at the Customs Division of Ghana Revenue Authority, which indicated a high propensity to engender corruption and corruption-related activities. Consequently, the Special Prosecutor directed the opening of a wider investigation in respect of the affairs of the Customs Division. Further, in pursuance of the office's mandate of taking steps to prevent corruption, the Special Prosecutor directed remedial action by Ghana Revenue Authority. The authority has instituted processes on the basis of the Special Prosecutor's Directive, which has saved the nation substantial revenue. Then comes the problem. The affected customs officials proceeded to the High Court to challenge the work of the OSP. The judge accused the OSP of constituting itself into a court and a commission of inquiry by making findings. In doing so, the judge conveniently shut his eyes to an express statutory provision that the OSP has the mandate to publish detected acts of corruption, and that was exactly what the OSP had done in the report. I wish it had ended there, but worse. The judge then proceeded to prohibit the OSP from further investigating the affected persons. Members of the press, the judge fell into the grievous fault of what he accused the OSP of by outlandishly going beyond his jurisdiction with a purported clothing of the affected persons with immunity from investigation and hence immunity from prosecution. Members of the press, the duty and mandate of the courts is to apply and enforce the laws of the Republic, and not to grant persons immunity from criminal investigations and prosecution. A court cannot injunct the OSP from investigating or prosecuting any person. The decision to investigate and prosecute lies with the investigation and prosecution authorities, such as the OSP, and the OSP has at all material times carried out its power to investigate with candor and professionalism, being minded of the rights of suspects under its investigation. Members of the press, just as it is essential that anyone accused of a crime should have free access to the courts so that he may be duly acquitted if found not guilty of the offense with which he or she is charged, it is also of the utmost importance that the judiciary should not interfere with investigation and prosecution authorities in respect of matters which are within their statutory powers. It will be gravely inimical to public policy, the fight against corruption, and the administration of justice if the court stepped into this arena to decide who should be investigated, who should be prosecuted, and who should not. That is not the function of adjudication. The danger of this startling decision is again quite obvious. A judge has in the process granted two persons immunity from investigation, and in effect, immunity from prosecution. This decision opens up a calamitous deluge, as every person under criminal investigation will be encouraged to take out suits to injunct investigation and prosecution bodies from investigating and prosecuting them. Indeed, there is a live case involving the OSP now, in which someone has taken the cue to seek to injunct the OSP from investigating them. The real and present danger looms largely on the consideration that by so doing, persons under investigation would end up conscripting the judiciary to clothe them with immunity from investigation and prosecution. Members of the press, I do not intend to sound as though I am predicting doom, but we are facing doom. And this is it. With this development, it will not be long. A suspected murderer or armed robber would boldly walk to court with the unthinkable prayer that the court should injunct law enforcement agencies from investigating him. We are not suggesting that the OSP does not make mistakes. We are not suggesting that we are infallible and that every case brought by the OSP or against the OSP should end in a favorable outcome to the OSP, no matter how improbable the evidence. That is not what we are saying. However, it seems to us that this flagship public agency created by law to fight corruption should receive better regard and consideration by the courts, and not this developing trend of dismissiveness and regression without regard to its governing enactments, and certainly not the erection of non-existent hurdles in its work and operations. I wish I did not have to say all this, but it bears saying, and so I have said it. It is our duty as the Office of the Special Prosecutor to bear these things out. Members of the press, I proceed now to announce the commencement of investigation and corruption risk analysis in respect of the following matters. Number 1, government payroll. The OSP has commenced corruption risk assessment and investigation into suspected corruption and corruption-related offenses in respect of Government of Ghana Payroll Administration. The assessment and investigation are especially aimed at isolating and removing non-existent names, recovering wrongful payments, and the prosecution of persons suspected to be culpable for any offenses. The Controller and Accountant General's Department is actively collaborating with the OSP on this investigation and assessment. Indeed, a joint project team of selected staff of the two institutions has been formed. The investigation and assessment will cover all banks and employees on government payroll. The exercise will be carried out in 2 phases. Phase 1 will cover Ghana Education Service and the health institutions. Phase 2 will then cover all other metropolitan, municipal, district assemblies, ministries, departments, and agencies. Number 2, Tema Oil Refinery. I know some of you went ahead of me because a document that was not supposed to be brought to light was brought to light before my announcement. But hey, you are doing your work as media, so kudos. Tema Oil Refinery. The OSP has commenced analysis of the risk of corruption in respect of the proposed partnership agreement between Tema Oil Refinery and Tema Energy and Processing Limited. The Special Prosecutor has directed the management of Tema Oil Refinery to immediately suspend the proposed partnership agreement, ongoing negotiations, operations, and all other ancillary activities arising out of and consequent upon the proposed partnership agreement until otherwise advised by the Special Prosecutor to enable us to timeously conclude the work. Number 3, state lands, stew lands, and other vested lands. The OSP has commenced investigation into the appropriation, sale, and lease of state-owned lands and properties to individuals and corporate bodies since 1993. The investigation covers all lands and properties that fall under the direct stewardship of the Lands Commission, the Ministry of Works and Housing, all other ministries, state housing company, state-owned companies, and other state agencies. The investigation also covers the management of vested lands and all public lands over which the state's ownership or control has been relinquished and the conditions of the release and relinquishment. Celia Dapaah. It will be recalled that in July, the OSP commenced investigation in respect of suspected corruption and corruption-related offenses regarding large amounts of money, mainly in foreign denominations, and other valuable items involving Ms. Celia Dapaah, former Minister of Sanitation and Water Resources, and her spouse. It will also be recalled that the office took several steps, including freezing Ms. Dapaah's bank accounts and investments, and seizing large sums from the residence of Ms. Dapaah and her spouse. It will further be recalled that upon the refusal by the High Court to confirm the freezing and seizure orders, The office re-seized the cash sums and refroze the bank accounts and investments and applied to the court again for confirmation. The matter is still pending. It will be further recalled that the investigation became cross-border and transboundary upon the claim by persons of interest that part of the seized cash sums was transported into the jurisdiction from the United States. For that reason, the Federal Bureau of Investigation, FBI, of the United States became involved in a collaborative investigative work with the OSP on the matter. The investigation has been largely aimed at determining the sources of the large cash sums. Members of the press, we have had the benefit of 5 months of investigation, and the circumstances of the case are clearer to us. The investigation appears to show that parts of the case are in the province of money laundering and structuring. The OSP does not have a direct mandate in respect of money laundering. Therefore, the office will be inviting in law enforcement agencies that have a direct money laundering mandate for collaborative work in respect of those parts of the case. And as we also await the outcome of the FBI investigation in the United States. Members of the press, almost a year ago, in a radio interview, I posed the question whether we are ready to fight corruption. This question had nothing to do with the preparedness of the OSP. It had everything to do with all of us, every citizen and resident of Ghana. I proceeded to answer the question with an unhappy outcome. It seemed to me then that we were not ready to fight corruption, and I tabled reasons for my conclusion. Chief among them being our collective tendency to largely remain silent, or at best render half-hearted commendation when anti-corruption agencies proceed against persons we dislike, and mercilessly tear to shreds the agencies when they repress corruption in respect of our associates. I do not intend to pontificate. However, I have to say this. We must uphold our institutions and strengthen them, especially our law enforcement agencies. We should not take the relative peace and security we presently enjoy for granted. Globally, we live in very troubling times, and we must guard our small slice of heaven at all costs. Members of the press, the OSP must be supported in its work. Should the OSP fail, Ghana would utterly lose the fight against corruption, with its attendant erosion of our democracy. Allow me to pose the question again. Are we ready to fight corruption? May God bless us all. May God bless Ghana. I hope you don't have any questions, but if you have questions, Elton would definitely have a question. I saw his hand first. So.
Thank you very much. My name is Elton Glover. I work with Joy. So the earlier matter is about the posture of the court or some judges as it relates to the many cases that you have brought before them. You seem to be working on that. There appears to be some kind of scheme to make the work of the OSP difficult, because eventually whatever you do, you have to put it before a court, for the court to make a determination on it. The court determination on some of the cases that you spoke about, do you understand that it's not founded on law, or it's just that the court is making the work of the OSP? And if it is so, that there appears to be some frustration in the way you're doing about it, would it be right to just say that we have to see that I'm resigning?
It's not a scheme, as I put it. What we have noticed is a trend. And you will notice that I hardly speak. And it is for a reason. My job is not to go around talking. My job is to do exactly what the law says. And in respect of the mandate of this office. I came into office August 2021. Took me about a year to sit down and to at least find a seat to sit on. Then we commenced hard work, even as we were trying to fix the place up. Then we started putting the cases in. You get an outcome of one case, you note it down. You get the outcome of another case, you note it down. Now, after August 2023, I've been in this office for 2 years. I can sense something going on. And the way I put it is that there appears to be a developing trend of dismissiveness and lack of regard for the work of the OSP in respect of some of the judges. Is it a matter of we didn't follow the law? I'm always the first to admit a mistake. And so when I assumed the reins of this office, and I considered, for instance, a member for Boku Central's case that was before us, I quickly, when we came to the conclusion that we did not have the evidence, I went to court and entered a nolle prosequi, because I did not believe that we could prosecute that matter successfully. Same with the recent investigation report we issued in respect of the former Minister of State at the Ministry of Finance, Charles Aduwahin, because we did not believe that we had an okay case to go to court for prosecution. And that is our style. We do not force feed cases. We do not force feed prosecutions. It is our belief that it is not a matter of us going beyond our mandate, but rather a case of hasty dismissiveness and lack of regard. Because if you take the 4 cases I tabled out over a period of time, it all spans from July 2022 to Monday, this very Monday, there's a troubling trend. Okay. Now, one of the cases I said, a judge injuncted us from arresting a person. Mind you, we were not in court because it was an ex parte application. We had declared the person wanted as a fugitive from justice. There was absolutely no inquiry as to why we believed that the person was a fugitive from justice. So it is not as if we breached the law. No one asked us why you declared the person wanted. But then we were here, served with an injunction or that we cannot arrest the person. Meanwhile, we know that in our law, no one has the right not to be arrested. No one. You cannot say, I'm granting a person a right not to be arrested. So, when we receive judicial decisions like that, it beggars belief to us that we will be prevented in arresting a person who we believe to be a fugitive from justice. What if we were not investigating corruption? What if the person was a suspected murderer, as I said, or a suspected armed robber? The person will be running around in the streets with an injunction on law enforcement agencies not to arrest him. This is not a breach of the law by the OSP. This is dismissiveness of his work. A judge is seeking to prohibit investigations. It's unheard of. You may disagree with us with the outcome of our investigation. That is a debate of the law. We're all lawyers. You got elevated to the bench because you're a lawyer. Law is not an exact science, so 1 + 1 is not necessarily 2 in the law. depends on what you can establish. But then again, no one has the right in Ghana not to be investigated. And the statutory power to investigate for corruption and corruption-related offenses is that of the OSP. So if a judge seeks to injunct or prohibit an investigation, the judge is arrogating the power of the OSP to himself. You get it? By deciding who should be investigated and who should not be investigated. But it is not the duty of the court to do that. Wait, let us bring before you the body of our investigation as evidence. Now, if you look at it and you decide that the evidence does not show up to the standard of proof required in criminal cases, then you can dismiss it. But don't prevent us from doing our work, from investigating. It is dangerous. As I said, I wasn't sounding as a prophet of doom, but there is doom looming ahead of us. That very soon, a murderer will boldly walk to court to seek an injunction. Should I feel frustrated and resign? I took an oath when I was sworn in. And in my life, when I take on the reins to do something, I do it to the best of my ability. I ought him. Those who do not understand tree, please forgive me. They say I'm a unkwanoma. Me de me cry abo afore. Me hear de me to me. Emre so a eko. Yes.
I'm Joseph Akabli. I work with TV3. I mean, first
Joseph.
Akabli.
Right. Oh.
First, I want a bit of clarification on some of the cases that you make reference to. The first is on the Celia Dapaah one. Am I to understand that, like happening in the Charles Oluwaye case, you are terminating the investigation at this stage because you said the borders on money laundering and you are inviting other agencies?
That's not what I said. Let me quickly dispel that. I said that. I didn't say we are terminating the investigation.
No, I'm asking because you said what you found now borders on money laundering.
Let me put it again. I said that we have 5 months to investigate so far, and things are clearer to us than when we first began, of course. And it seems to us that parts of the case have to do with money laundering and structuring. And the OSP, we do things by law. If we do not have the mandate, we do not have the mandate. We have not been given, we have corruption-related mandate. But when institutions have a direct mandate to investigate and prosecute for some specific offenses, we shouldn't force ourselves into doing it when another state institution or agency has been given that mandate. And so we will be inviting in the state institutions who have the direct mandate in respect of that aspect of the case. You get me? So that we will be doing a collaborative work with them, like what we did with the FBI. Because we do not have jurisdiction in the United States, and some money said to be coming from the United States. But should we just sit? And the FBI took interest, and we are collaborating with them. The same way, if we found something that we think that this is in the province of money laundering, it will be irresponsible not to bring in the other state agencies who have the direct mandate. So that is what I said.
Yes, so the question is there an aspect of the case that is still within your remit that you are investigating?
It goes without saying. It goes without saying that if aspects are going to be given to, or if we are inviting in other state agencies in respect of that which we believe to be money laundering and structuring, it means that there are other aspects that are still live with us. You get me? You remember I said that we're still waiting for, if I didn't say it, permit me. So we're still waiting for the outcome of the U.S. investigation. We do not have the benefit of that yet. So that we cannot just let go things when we don't have the result of what they did, because they will then collaborate with us and inform us as to what they found, and that will inform our further action.
The second question has to do with the Tema Oil refinery matter. This morning I have have seen a letter written by the Tema Energy Processing Company, the Tema Refinery, indicating that they are no longer interested in the transaction. I don't know what this means for your investigation, because if I understand your release, it was a corruption risk assessment and prevention that you were trying to undertake. And the final question has to do with a bit of follow-up to what Elton had asked earlier. There are some of the operators who question the quality of work that is being done in the office. And for instance, they made the point that how do you reconcile the position of Charles Eluwan with the Bianca one? The point is that if you don't have the mandate and the influence by is not an offense in Ghana, then on what basis do you issue those directives to the custom officials? Because the claim in the La Bianca case was that there was influence peddling in respect of the owner of the company, which resulted in a tax reverse in that part. Thank you.
Right. Business decisions for people who engage in arrangements with state agencies. If they are not interested in it, it is their position on it. But that doesn't prevent our work, because we want to clean up things. And in cleaning up things with the corruption risk analysis, it is better we do it so that things do not reoccur. You see, it is better to set the ground rules for future action, so that we do not go back again to it and then have to rework our way back in respect of something that which should not have been done. And so, wouldn't it be responsible on our part if we still went in, looked at it, and then with Tema Refinery come to some conclusions? Do this, do that, do not do this, do that. This will save us money. This will give us value for our money. And you remember the opinion too from the Attorney General. Wouldn't it be better if we prevented all that in the very near future than to go back to the same thing if indeed another entity were to come in? You get it? See. Now to your last question. Not all cases are the same. Some look similar, but they are not the same. The La Bianca matter, we concluded that the evidence pointed irresistibly to one conclusion, that it appears there was some influence peddling or trading in influence. Otherwise, the officers who issued the customs advance ruling wouldn't have done that. We also concluded that there was no application for it. So it was as if the applicants had come to the customs officials with a blank sheet of paper. So if you have before you a blank sheet of paper and you manage to decide on the blank sheet of paper, something was operating on you at the time you were considering the blank sheet of paper. Let's say you are an examiner and you receive as question to examinations a blank sheet of paper from a candidate, and you proceed to grade the blank sheet of paper and score 90 over 100, let's say. Shouldn't we be asking questions as to how you arrived at 90% when there was nothing on the sheet of paper? This was our concern in the La Bianca case, that even though there was no application, there was a decision. And so to us, it seemed that there was a corporate culture that even without applications, customs advance rulings were being churned out to people. And that is why we did not end that investigation. We haven't ended that investigation. What we said was that a special prosecutor was directing further and wider investigation to open it up and to examine other customs advance rulings. Therein lies the difference. Therein lies the difference. With Charles Dapaah, we came to the conclusion that what he engaged in amounted to influence peddling and trading in influence. We combed through our laws. We did not find any criminal prohibition in respect of which the OSP had a mandate which we could proceed against him. Although we found that what he did was improper. But engaging in improper conduct doesn't necessarily mean that that is a crime. Do you know that in Ghana, you can have sexual intercourse with your auntie? It is not a crime. It is not incestuous by our law. Just because we all find it to be opprobrious, why are you sleeping with your aunt? Doesn't mean that it is a crime. So, coming to the conclusion that he engaged in influence peddling, he engaged in trading in influence. But that is not a crime in Ghana. And we recommended that we need a Corrupt Practices Act to firm things up. Otherwise, all these loopholes that have been created by the way we have structured our laws will inure to the benefit of persons who engage in acts like that. You see the distinction. In one case, we're saying there was a blank sheet of paper before you. You managed to score the blank sheet of paper and give it 90% over 90 over 100. What if there are other blank sheets of paper in respect of which you are scoring people? And so we are opening up the investigation. Let me come to this region. Yes, sir.
So my name is, I'm sitting because of the cameras that are behind.
You should have been standing.
If I stand, I will just...
Oh, right.
Yes.
But you don't need to stand.
Okay. My name is Wilberforce. I work with Assassin Radio.
I know you.
So there are, I've heard some people raising concerns that the Special Prosecutor's Office is an investigative institution. And one of the things associated with investigative institutions is that you would always approach your work with some level of secrecy. Now, they are also saying that it would appear that the Special Prosecutor has, out of its mandate, the law that establishes it, a responsibility to disclose. And so it would appear there's a conflict between that level of secrecy that is required from an investigative institution like the OSP and that mandate that is also given to disclose. And it is that conflict of, not conflict of interest, obviously, but that
I know it occurred to you.
that conflict of responsibility that appears that the Special Prosecutor is always out there giving out information as to the work it is doing or not doing. Whereas some people think that the Special Prosecutor should be quiet about some things. And then when it is completed, then make disclosure. So I just want to pick your thoughts on it. This opening in your law that says publish, make known, as against the fact that you are an investigative institution and should be doing certain things by secrecy so that when it is up, because they say that Office of the IOCO is investigating several issues that nobody knows about. The Attorney General's Department and other investigative bodies, as we speak today, they are investigating so many issues, huge issues involving huge monies that people may have stolen from the state and all that, but nobody knows about it. So why should the Special Prosecutor's activities be so public and be discussed and others? Maybe, I don't know if I asked my question well, but that's the question that people have the list of people, and I think that you should address.
I understand the concern. I hope I wrote the law, but I did. We apply the laws we are given. Parliament passed the laws. We have a duty to educate the public. We have even been required to make half-yearly publications. Which other institution has that requirement in respect of investigations? The law specifically states that every 6 months we should publish out there on our website and in 1 or 2 dailies the work we are doing, the investigations we are carrying out, the cases before the courts, the outcome of the cases. This is the law. Would I, or should I say, yeah, this is what the law says, but we can't publish it. But there's always a balancing act.
Should we call for amendment?
Oh, as for the law, I'll be asking for several amendments, but I don't want to go into that. In respect of calling amendment for this one, there's a reason for this, and that has to do with transparency, which I talked about. The nature of corruption, as I said, my briefing to you, is that it's carried out in secrecy. If two persons are corrupt and they engage in a corrupt action, it's very, very difficult to unearth it if one of them, for instance, doesn't spill it out. See? So, and that is how corruption thrives. So if you do not fight it openly, you will be stultifying yourself and shooting yourself in the foot. But there's something we do here. When you see that we have come out, it means that we've gotten to the threshold that we believe we must come out. And, you know, I stated also in my briefing to you that we consider whether our publications would endanger national security. We consider whether our publications will affect ongoing investigation. We also consider whether our investigations will ruin the reputations of the people we are investigating. We are sitting on hundreds of cases. How many are out there in the public? There's a threshold of preliminary investigation. When we go beyond the preliminary investigation, then I will direct for a full investigation. Now, during the full investigation, when it is time that we should inform the public, then we come out to inform the public. So, we've not even informed the public 2% of the work that we are doing. This is a requirement of the law. You will be the same person to turn around and say, the Office of the Special Prosecutor is required to publish half-yearly reports. The SP has been here for more than 2 years. Not even a single report has come out. We always guide ourselves with that old tale of the man, his son, and the donkey who are traveling. Everything you do, someone will have an issue with it. You cannot satisfy everyone. What you can only do is to look at the law. What does the law say? And follow the law. Yes, sir.
My question has been answered, but let me.
Oh, then why ask? Okay. Yeah.
So, you said the courts have been dismissive of your work.
Let me write it. I'm saying that it appears to us that there's a developing trend of dismissiveness and regression, and I have given 4 instances.
Great, fantastic. Would you say that, and Elton asked, are the courts acting within the law or they're outside the law?
I answered. In the 4 instances I gave, they were outside the law.
Right.
Yes, and that is why I said that the instances I gave, I said, look, no one has a right not to be arrested. No one has a right not to be investigated. So if you say that, don't arrest the person, we have declared the person as a fugitive from justice. You do not know why we declared the person as a fugitive from justice. You did not call us to ask us why we declared the person a fugitive from justice, but you say don't arrest him. That's dangerous to national security.
Great. Then the second one is this. The pronouncement that says that you would refer to as some trend. Are there options open to the office, or that is the end of the case?
No, there are options. We can always go up higher.
Why are you frustrated?
I didn't say I was frustrated.
You look frustrated.
Oh, really? Maybe I was born this way. I'm not frustrated. He has a question whether, in the light of frustrations, I'll resign. And I answered, well, I'm not frustrated. I'm not frustrated, but I need to sound that caution. But we are on slippery grounds. And it is our duty as the Office of the Special Prosecutor to point that out. That is our mandate, to point that out, that we are on slippery grounds. And indeed, we are on slippery grounds. It is encouraging people to go to the courts to seek injunctions against investigations. That's dangerous. And so, in answer to that, it's outside of the law to say that. I didn't discuss the steps we've taken in the courts to challenge all that. But if we see a trend, it is for us to point out that there's a concerning trend that we need to halt, reflect, and turn around from. Yes, sir. Ernest, which media house? Okay.
So my question has to do with something I read regarding the Celia Dapaah, Honorable Celia Dapaah's case. The author was trying to question why you went to court when you don't have a specific charge against the former minister. From the author's view, your charge of corruption and corruption-related charge, the offenses is not a charge. That's something that is within your mandate that you have to investigate. So if you go to court and you go and tell the court that I'm investigating Mr. A or B on corruption and corruption-related charge, for the author, that is vague. You needed something substantial to tell the court to be able to charge the person. So
the person making a suggestion.
So my question is,
it's easy to bash.
So my question is, when you went to court, what was the charge against the former minister?
And this is the entire problem of this whole regime. The regime of OSP's regime. Let me situate it in a proper context. The OSP's regime, in respect of confirmation of freezing orders and seizure orders, is very clear in the law. And I commented on it in my earlier briefing. See, if you do not carefully look at it, you will fall into this error your author is falling into. You'll be putting the cart before the horse. And in our estimation, that is what the court did, by putting the cart before the horse. See, that regime is quite different from the regime of, let's say, Yoko. Their law is different from our law. In our case, the law says, look, if the special prosecutor considers it necessary that the freezing is required to facilitate an investigation. So whose reckoning are we taking into consideration? It is the special prosecutor's reckoning. That he considers it necessary that the freezing is required, so that the freezing will facilitate an investigation. It tells you that the investigation is now commencing. Now, the commencement of an investigation, if any investigator will tell you that the commencement of an investigation, they know what they are going to find, then probably they should go back to investigation school. Also, when you commence, you come across so many things which lead you to so many avenues that you did not even consider when you began. So, not to put the cart before the horse, you commence from the special prosecutor's reckoning that this freezing is required to facilitate the investigation. It means that we are now going to go into the investigation. But if we leave the person to freely use these assets, the person will scuttle it. The person will hide the assets. At the end of the investigation, we would have shot ourselves in the foot if we come back and say, oh, yes, we finished the investigation. This amount of money is as a result of this corruption offense. But where is the money? Money is gone. This is what the law is trying to prevent. But you see, there are safeguards. The law then starts giving time limits within which the office should act. So hold your horses. Let the office work within its time limits as to its investigation before you can then start questioning whether the office is doing a proper job or not. But in the heat of the commencement of the investigations, searching several residences at the heat of, and you want an outcome already, you get it. And that is why I was asking you jovially whether the person had any suggestions. And I said earlier that after 5 months, we are seeing things clearer. Which ones to take? Remember, not too long ago, we defroze some of their accounts. We defroze 5 of their accounts because after investigating, we can't hold a person's account and investment perpetually when we realize that those accounts had nothing to do with what we were investigating and they were of no import or purpose. We just let them go. And that should tell you. You see, but from the onset, you cannot determine that unless you are God. Yes, sir. I'm still here. Today, I'm like the speaker. You haven't caught my eye.
Yeah. So, my first question is, give us a hint about some of the cases you wanted to pursue.
Those were not hints.
You mentioned the health and the...
Those were concrete investigations.
My question is, why start from there? You mentioned phase 1 and then phase 2. Is that to suggest that you have a certain kind of information, that is why you are starting from there? My second question is, you mentioned...
If I may answer that quickly. The Ghana Education Service and the health institutions, they form the bulk.
You're still watching Newsdesk, and just before the break, you've been hearing from the Special Prosecutor, Mr. Kisieja, being, giving some pointers about his cases and that are being decided on by some judges in the court. Obviously, been releasing some bombshells about the cases that are before certain judges, and he hasn't mentioned any judges yet. But let's go back and hear more about that. We'll deal with that shortly.
You don't have kids and you are building and you are not reckoning kids or how many kids you have, and you put up a 3-bedroom house, and then your wife goes to the neighborhood and quadruplets.
My last question would be, you mentioned the fact that some of your friends have admonished you and raised concerns as to your conduct and your, if you like, write-ups in terms of the judicial decisions. And they say some of these things are going to be a stumbling block for you. And today you are doing exactly the same thing. Why do the things that they say would stop you from achieving your ultimate goal?
I have a charge to keep. The charge is the law. What the law says the OSP should do. Once again, it's like Wilberforce was winding up. We have a mandate to let the public know. Imagine after these 2 years, all these cases that we've done are kept quiet on it. We will be holding a stick full of me. That is what the law says you should do. So it's not really about what someone says. Always your recourse should be, what does the law say? Because I listen to them. These are well-meaning lawyers. As I listen to them, they say they've heard talk. Why? That's the judges will not be happy with the way we do things here. I'm saying this institution is so novel. We are still trying to understand what we have created. Indeed, so many of the agencies don't even understand the work of the OSP. We are invite debate, as I said. We will debate, but every time we have to anchor ourselves in the law. I'm saying the reason why we do that, one, the right of the public to know, and then to state our position on what we think about the judgment. In my days as a lecturer, if I write a law article journal, it's published, let's say, University of Ghana Law Journal, Cambridge Law Journal, judges will complain. Secretary
We're still covering live the press media attention. The OSP is spearheading and currently answering questions from journalists. And to take us through a quick summary of some of the things he's been saying, he says that there's been some aggressive judicial judgments that have been hampering his work as the OSP, and also the bit about it's been highly unusual and suspicious for government officials to keep large sums of money in their homes. Also, we've been hearing the OSP making allegations of some judges, being very dismissive of his cases and whatnot, mentioning a number of cases, including the Bianca case, the Toll case, also the Celia Dapaah case as well, and all these things making, raising concerns about how judges presiding over these cases have been treating it, and is very, very uncomfortable with how they are going about some of these cases. Also, the OSP has been making fears that if that is the trend that is going to go, it's going to be very difficult for Ghana to fight corruption, and needs everybody on deck to help him fight corruption. He also says he's not frustrated about the work that he's doing, but we all live to see what happens after these bombshell statements that is made. But we can go back there to the OSP's address and hear what's going on.
We give the media those figures, or was the media that was projecting that those should be the figures? Once again, on that, if you have gone there, we're not responsible for those publications. We cannot be attacking every media house that, oh, what you put there is wrong, what you put there. That will be, we'll be going beyond what the law says we should do. But what our responsibility is to correct impressions, is to correct what we put out as facts, if that is not what we do. That is why when we put out our official statement as to what we found, we put it out there, this is what we found. You get it?
Yes, excuse me, sorry. I've been told that members of the audience cannot hear the question.
Yes.
So you may approach the lectern a bit so that we can hear your question.
The sound has been up all this
So if you can approach your lectern a bit.
All right.
So what is that? Yes.
What if he comes to slap you?
I'll show you around. Why did you buy my house?
I've left it off with
Two quick things. First of all, you talk about now you having your full staff strength. Now let's talk about budget.
Keep going there. We do not have the full staff strength. We have it as it should have been 4 years ago.
So
that's a difference.
This should be improved. I want to talk about finances. Yes. We've heard complaints about inadequate funding relative to budgetary allocation. I want to zoom in to find out really this. For instance, this year, if you can give us an update about how much is allocated and how much has been released, and what is the case. And finally, the trend, the dangerous trend we talk about relative to the 4 cases of site. Yes, you are indicated that you are going to appeal. That's understandable.
But did I say that?
No. Oh, okay. But the releases we've seen, some of them is indicated.
I don't discuss strategy like that. For a moment there, I thought this was a parliamentary budget hearing. Please, my budget hearing is next week. Allow me to go to Parliament and deal with them. But I do not disclose such figures when we are not ready to disclose such figures. Such figures are, first we discuss with the Minister of Finance, and if he has to go, but everything is in the budget. Yeah, everything is in the budget. And we're also audited. There's the Auditor General's report. Yeah, so if you are really minded, you can find them. But really? You are able to read into meanings into what I said by saying I'm going to appeal, but you've not been able to read the meaning into the fact that I'm crying for help. Is anything enough in the public sector in Ghana? It's not. It's not near enough. See, I said want to go to Kumasi, Tamale, and Takrady. It requires cash. Right. And then seeking audience with the Chief Justice. I do not want to discuss substance. Okay, right. As to what one head of institution discusses with the other, let's leave it between ourselves, right? Okay, right. The last one. You won't allow the lady to ask the question. Not a single lady has asked the question. So allow it.
My name is Hansen Ajaman. My name is Hansen Ajaman. I work at CTFM, CTTV. In one of the cases you referred to, the judge indicated that you were motivated by media frenzy. At the tail end of your statement, you indicated that a lot of people react based on how they relate with persons you are investigating. I just want to find out, to what extent do public commentary affect your work, considering what the judge has said and your own admission of public commentary on your work? Thank you.
So you will realize that in our release after that ruling, we disagreed with the judge that we were acting based on public sentiment. It is our investigation that sparked the public conversation. Mind you, we had started the investigation before even it became public. But once again, like Wilberforce said, we were not ready yet to come out with what we were doing because it was still at the preliminary stage. So to tell us that we were driven by public sentiments, it was most unfair. See, and then to go on to say that to chastise us for finding the money in her house, as if we shouldn't have taken any action at all. Once again, Ghanaians would then turn around and say, "Oh, so the persons reported a large a foreign sum of money stolen from their house, and you didn't even go to their houses." You get it? And so to actually fault us for going to find more money in the residence, it's unfair. You get it? What was the tail part of your question?
I referred to your statement about the reaction of Ghanaians to investigations, dependent on how.
Yes, as to no. See, we have people who every day go through everything being said or discussed in the media, social media, everywhere, in bars, in nightclubs, in, maybe I'm revealing a lot, in pubs, everywhere. It is our duty to know what the public is saying and to fashion our actions. A state institution that disregards a critical mass of public opinion would eventually kill itself. But once again, our work shouldn't be fashioned out by what the public is saying. Our work should always be fashioned out by what the law is saying. So yes, we listen to the public. We examine the positives. We take the bashing in good faith. It's never going to be an easy job. Everything you do about it is not palatable. People will hate you. We appreciate that and we know that. But we're not going to be crying over that. But just because people are bashing us doesn't mean we should then turn around and do what they are saying because they are bashing us. Once again, back to the man, his son, and the donkey situation. When the man is sitting on the donkey, one person meets them. Look at this wicked man. Why are you sitting on a donkey and your poor son is walking? They reverse roles, they meet another person. Look at this disrespectful boy. If we behaved like that, we will leave the law aside and be doing our work based on what people say. You get it? So there's a balance. Listen to what people say, but we situate it in the context of the law and let the law be our guide. Last.
Anyway, quite a number of questions. My name is Ifua Mensah, and I work with UTV. And forgive my naivety on some of the questions. Okay, so some of the questions will be, let's say, from the ordinary Ghanaian or somebody on the streets. The Article 88 of the 1992 Constitution, it says, I'll read some of the questions out. So it says, it clothes the AG with a responsibility for the initiation and conduct of all prosecutions of criminal offenses. It means that the OSP derives his prosecutorial powers from the AG. Will he therefore recommend an amendment in this constitutional provision so that he does not derive his powers from the AG? And then there are plans to review existing plea bargaining system and other alternative methods of resolution to encourage cooperation and expedite corruption cases. Other plans, sorry. And how would you say, how will success in your role be measured? And what specific goals or benchmarks have been set to gauge the impact of your office work in combating corruption? Quite a number, I said. So what plans does your office have to educate the public and raise awareness about the negative impact of corruption on society and the importance of reporting such cases?
Madam, this requires a whole letter.
Do you believe that the existing legal framework adequately supports your office's mandate, or are there any reforms you foresee pushing for? Then let me scroll down to maybe my personal ones. Yes, the last one. So you're saying that the OSP is certainly not against the judiciary, and that why would judges gang up against the office, and that whether we are ready to fight corruption, it seems we are not ready. And so the question then is it that you want to feel some kind of power ahead of the judiciary, or let's say the judges? Because then the question is, are you at par in terms of the role that you play? Okay, I'll end it.
I wanted you to leave before. Who knows? Ladies can also slap. Let me answer your last question. See, I did not say the judges have ganged up against the OSP. I'm saying that there's talk from well-meaning lawyers who call me that there's that danger. And I ended by saying that we muse and we conclude with a sigh that we do not know them like that. And it can't be. But then there's also a trend, developing trend, that there's dismissiveness of the work of the OSP. I've cited 4 cases. And there's regression in respect of these decisions. It is not a question of being at par with the judiciary. Each institution has their role and function to play. You get it? Our role and function is to investigate, prosecute, recover assets, and take steps to prevent corruption. The court's role is to adjudicate. So, if we don't investigate and bring cases before the courts, they can't move. The courts themselves cannot come onto the street to investigate, arrest people, and bring them before the courts. We have to feed the courts with the cases. So our work is complementary. What we are saying is that, with the 4 instances I've cited, there's disregard for our work. There's dismissiveness of our work. And so we're asking for better consideration, situated in the context of our law. Once again, the office is novel. Everything about it is novel. So everyone is trying to figure out what this office is all about. So take your time and see what the law says. Take your time and consider our actions rather than being dismissive of it. Because maybe you may have missed something. All the questions you asked previously is in respect of law reform. Or everything you ask is in respect of law reform. Yes, we have tested the enabling enactment and the allies so far, and as every human institution, there are always gaps and loopholes somewhere, and so are they. We are putting together a body of opinion in respect of the amendments we'll be placing before the appropriate authorities. As for Article 88, it's also in respect of